Hey everybody, welcome to Smashing Patriarchy. And by smashing, you know that I mean deconstructing it, taking it apart. Let's take a look at it. I'm your hostess, Michi Main, your main girl. Today we're going to be discussing equal rights. And by equal rights, I mean guaranteed equal rights for all citizens regardless of gender. Now let's get smashing. So the ERA, the Equal Rights Amendment. It is a proposed amendment to the United States Constitution that is designed to guarantee equal legal rights for all American citizens regardless of sex. It seeks to end the legal distinctions between men and women in terms of divorce, property, employment, and other legal matters. A patriarchy is a social system in which males hold primary power and they predominate in roles of political leadership, moral authority, social privilege, and economic control. In a patriarchal system, only males are actually guaranteed full rights of citizenship. Currently, in the United States, only males are explicitly protected under our Constitution. Everyone else is subject to legalized and government-sanctioned discrimination. Gender discrimination is rampant throughout our criminal and our civil court system, at home and in the workplace. Equal rights have not been achieved, and even if you believe that all genders do have equal rights in this country, then codifying it into our Constitution should not be a problem. Right now, even already 80% of Americans believe that equal rights are guaranteed already under the U.S. Constitution. But they're still not. It says in Section 1, equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. It's really very simple, like 24 words that make it very simple. First proposed by women suffragists in 1923, it was adopted by Congress in 1972. The measure was then sent to the states for ratification with a 7-year deadline. When the deadline passed in 1979, Congress extended it to 1982. Equal protection under the law, that means when a woman calls the police, she needs the same chance of them showing up and arresting perpetrators as when a man calls the police. That's one form of discrimination. Right now, yes, only males are explicitly protected under the U.S. Constitution. Honestly, women are discriminated against in courts every day, all day, where males still currently have a clear advantage. Setting a court standard would only help matters. Making it clear that discrimination is unacceptable is a necessity, just in the very least to get courts to be fair. Make sure that they're fair. Gender bias is in the court system is well documented, and women are at risk as long as there's no higher court to guarantee us the equal rights as citizens. So, Equal Protection Clause of the Constitution's 14th Amendment, some people say that the 14th Amendment is enough to guarantee equal rights for everybody in the Constitution, but it's not very specific. Well, it's not specific to gender at all, and it doesn't prohibit discrimination based on gender. For the first time, sex would be a suspect classification requiring the same high level of strict scrutiny and having to meet the same high level of justification, a necessary relation to the compelling state interest that the classification of race currently requires. So you can claim racial discrimination, and there's a federal standard for classifying what that is. But there's not any federal classification for sexual discrimination right now. I mentioned before that some people believe that women are protected from sex discrimination under the 14th Amendment. The first section of the 14th Amendment does state that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person with its jurisdiction the equal protection of the laws. This amendment to the Constitution was adopted as one of the Reconstruction Amendments, which addressed citizenship rights and equal protection of the laws, and was proposed in response to issues related to former slaves following the American Civil War. It does not explicitly protect citizens against discrimination based on gender, right? No, it doesn't. No, it doesn't. So it wasn't until as recently as 1971 that the 14th Amendment's Equal Protection Clause was first applied in any sex discrimination case. Even today, a major distinction between the sexes is present from the moment of birth. The legal different standing of males and females with respect to how their constitutional rights are obtained, as demonstrated in 1996 by the last major Supreme Court decision on sex discrimination, which dealt with the admission of women into the Virginia Military Institute. We have not moved beyond the traditional assumption that males hold rights and females, if treated unequally, must prove that they hold them. So, okay, the First Amendment does guarantee a certain degree of equal rights, but only if we prove that we're worth those equal rights. It's not automatically guaranteed in the 14th Amendment, so that is not a fallback. Without the ERA, women regularly and occasionally men have to fight long, hard, expensive battles in an effort to prove that their rights are equals to those of males. The Equal Rights Amendment would remove that differential assumption and conclusively invalidate the claim of Justice Antonin Scalia, the late justice, that the Constitution, specifically the 14th Amendment, does not protect against sex discrimination. So, discrimination continues throughout the U.S. legal system in civil and criminal courts. From family courts where mom actually only win 10% of their custody cases before judges, and in criminal cases where violence against women continues almost certainly without consequence. Only 3% of rapists ever see a day in jail, and that's just of the reported rapes, for example. Right now, there is a push by Democrats and others to revive the Equal Rights Amendment. There's actually a current push to extend the deadline again, just recently since Virginia's blue wave swept the state. Virginia wants to be the last state to ratify it. Right now, only 37 out of the 38 states have ratified the amendment. And we can get that bill through the Senate, then the ERA will pass. So, however, both the Senate and the Republican-led Senate would have to vote either to extend the deadline or to ratify the ERA again. One of the suffragists behind the bill, Alice Paul, argued that, back in 1923, argued that we will not be safe until the principle of equal rights is written into the framework of our Constitution, or into the framework of our government. However, both the House and Republican-led Senate would have to evacuate the area because some 9-year-old kid just farted. While the House is likely to vote to eliminate the deadline, the measure's prospects in the Senate are uncertain. Senator Mitch McConnell of Kentucky, he's the Senate Majority Leader, and he's long pronounced the Senate a graveyard for progressive legislation that comes from the House. However, Republicans are looking to attract female voters. So the Equal Rights Amendment could very well be in the hands of Republican women. Hey, no more marshmallows. And actually, Republicans have a long history of supporting the Equal Rights Amendment. It was first incorporated into the Republican platform as early as 1940, and it was 4 years before the Democrats adopted it into their Democratic platform. And then, of course, it took 3 more decades for the ERA to pass the House and Senate with the required 2/3 majority. So what would the Equal Rights Amendment do? It would give us equal protection, for one. Keep on smashing. Say smash the patriarchy. Smash it.